Back, gentleman from Florida is recognized.
Thank you, Mr. Chairman. Joe Biden's DOJ has utilized their power and weaponized the justice system to go after his political opponent. From Florida, courts in Georgia, courts in New York, the farce that occurred in New York is a pathetic and sad abuse of the legal system by a rogue Democratic prosecutor and an obviously biased judge. As Judge Wilson aptly noted in his testimony, President Trump was railroaded and Judge Merchant drove the train. Not only did Judge Merchant seek to silence President Trump from informing the world about the judge's own conflicts of interest in the case, but he made sure to effectively muzzle President Trump's key expert witness, Professor Bradley Smith, on a central element of the case. Professor Smith, you correctly pointed out in your testimony that the district attorney's theory of the case revolved around a state law that prohibits promoting a political candidacy by unlawful means. In this case, the prosecutor alleged that the unlawful means resulted from a violation of the Federal Election Campaign Act. Is that correct?
That's correct.
And you were once the chairman of the Federal Election Commission, is that correct?
That is correct.
Given your obvious status as an expert in campaign finance law, can you explain why the definition of an expenditure is so important to the case?
Yes. The definition of this expenditure, if you just read the statute, says anything for the purpose of influencing an election. So a normal person might hear that and say, well, why did they make that expenditure? But if you read further into the statute, the provisions regarding personal use, and if you read the FEC's regulations and its explanation of those regulations, what is clear what they mean is for the purpose of influencing an election is not the subjective motivation of the spender, it's an objective motivation. So setting up a campaign headquarters, hiring a campaign manager, buying TV ads, printing bumper stickers, whatever else you do like that, that's for the purpose of running a campaign. But the mere fact that you do something that might be helpful to your campaign, like taking a weight loss program so you look better on the campaign trail, buying a house in New York so you can run for U.S. Senate from New York, settling complaints against your business in your private life, sealing your divorce records, those are not things that arose from your campaign. Those are things that people sometimes do anyway, and those would not be campaign expenditures.
And were you allowed to provide any of that context to the jury through expert testimony?
No.
And what is your expert opinion of the instructions that Judge Merchant gave to the jury regarding the Federal Election Campaign Act?
Well, I think the judge's instructions were clearly wanting. All he gave them was that bare bones. If this was for the purpose of influencing an election, you've got a problem. And again, as has been noted in this hearing, he repeatedly allowed witness Michael Cohen, who's no expert in campaign finance law, and the prosecutors to state that there had clearly been a violation. I would note that had I testified, of course, I would not have testified specifically to what the law is, but I would have testified to the reporting system that would have shown that there was no advantage to not reporting this as a campaign expenditure, to the contribution system, which would have shown that Mr. Trump could have clearly paid this without any ramifications had he wanted to do so. I would have talked about how the FEC in practice had in many cases found that certain things that look like, again, that for the purpose of were not found to be for the purpose of a campaign, and let the jury do with that what they will.
And Judge Merchant allowed Michael Cohen, who has no expert qualifications in this field whatsoever, to provide the jury information on campaign finance law, but he prevented you from giving substantive expert testimony on Federal Election Campaign Act.
He did, and then he advised the jury, now, you can't use that to consider Mr. Trump guilty. That's only for context, which is sort of like saying to the jury, or sort of like saying to you, for the rest of this hearing, I don't want any of you to think about a yellow minibus by Volkswagen. I mean, that's all you're going to think about the rest of the hearing is a yellow VW van. It kind of flagged it to the jury's attention that Cohen had pleaded guilty in this case under, I think, tremendous pressure because he was facing years and years in prison for tax violations. So he pleaded guilty to the campaign finance thing and basically got a much lighter sentence.
In the beginning of questioning by Chair Jordan, you talked about how we wouldn't want non-disclosure agreements of things that happened before a campaign to be campaign expenses. Can you just expand upon that?
Right. I mean, you don't want members of Congress to pay for their, personal peccadillos from year before or allegations of such. I think we should credit those just as allegations using campaign funds. You don't want a person to use campaign funds and say, gee, this is something really embarrassing to me that happened in my past. I think I'd like to seal that up, even though it's not relevant. It's not something that you created from your campaign. It's the ticket for abuse. And this is why the law specifically lists a number of things. Like, for example, you can't pay for a country club membership, even if the reason you have it is to raise money for your campaign, because it's something that people do even if they're not running for office. And we don't want campaign funds paying for that.
Thank all of you for being here today. I yield back.
Mr. Chair, I ask
Gentleman
you,
yields back.
I
Gentleman
ask
is
you-
recognized.